Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Greetings one and all. 4 decisions this week, and they're awesome, and I'll get to them in a sec. But before I do, I need to fall on my sword. On episode 158, at the end of the BIA's Matter of Morales decision, I lamented that there was no way for a new attorney to swoop in and file a notice of appeal with the BIA through EOIR's e-case system when that attorney hadn't represented the non-citizen before the immigration judge. It was a cry for help, nay, a plea for the BIA to fix the bureaucratic snafu. Well, it appears that I am the snafu. Yes, everyone, I was wrong. As far as I can tell, this marks a first in the history of my life. The day after the episode dropped, loyal listener Naveen Flores-Dixit, with American Gateways in San Antonio, wrote me to tell me that yes indeed, new attorneys can simultaneously file notices of appearance and appeals with the BIA. Naveen even provided me a helpful step-by-step PDF. Thank you, Naveen. And wouldn't you know it worked. I needed to wait to try it out before I fell on my sword publicly, but fall I must. And honestly, it was quite self-explanatory through EOIR's case portal, and it worked wonderfully. Really top-notch, and 0 complaints. So thank you, Naveen, and sincere apologies, BIA. This snafu was not on you. But while I have your attention, BIA, have you considered having e-case input automatic docket entry numbers to all uploaded documents, just like they do in federal court? You're already adding in the date and time of when a document is uploaded. Why not a docket entry number? It would save IJs from having to spend 10 minutes pre-individual hearing marking documents in the record. And it's an organizational blessing for practitioners. So what do you say? And don't worry, I triple-checked this time to make sure it's not already happening. Respectfully submitted. First up is Mukantagara v. DHS, published by the 10th Circuit on May 16th, 2023. This case is about jurisdiction. In this case, INA Section 242(b)(9). The plaintiffs are Miss Mukantagara and her son, who were denied refugee status by USCIS. A bit surprisingly, because according to the court, they are citizens of Rwanda who, quote, escaped to the United States following the 1994 Rwandan genocide, end quote. Ms. Mukantagara alleged that during the genocide she was attacked and raped, beaten by Rwandan authorities, suffered the murder of her husband, and was then herself falsely accused of genocide by neighbors. And so yes, indeed, she was actually admitted into the U.S. as a refugee in 2005 with, at her time, minor son. They applied for special adjustment of status for refugees in 2007, and then they traveled to Kenya on a refugee travel document. But upon their re-entry into the United States, Border Patrol confiscated their refugee documents. God knows what happened during the next decade, but in 2019, USCIS issued a dreaded notice of intent to terminate refugee status, quote, alleging that Ms. Mukantagara did not meet the refugee definition at her admission because she had participated in the genocide, end quote. Oh my. Ms. Mukantagara, of course, responded and denied the allegations, but USCIS terminated her refugee status anyway. Their mind was made up, as so often is the case with notices of intent to do anything. Her son's refugee status was also terminated too, as it was derivative-based. I wonder what happened to the pending adjustment of status applications. Probably denied. DHS then initiated removal proceedings, where an immigration judge determined that the IJ lacked jurisdiction to review USCIS's termination of asylum status. Doesn't mean that Ms. Mukantagara can't apply for asylum again before the IJ. It just means that the IJ can't decide whether USCIS was correct to terminate the refugee status. Of course, it all comes down to a similar question. Did Ms. Mukantagara engage in genocide in Rwanda? Well, quote, the immigration judge found significant reasons to doubt the genocide accusations against Ms. Mukantagara, so the IJ granted Ms. Mukantagara's new asylum application, end quote. And just to be clear, everyone, I am only 3 pages into this decision, and this is one of the more interesting ones we've had in a while, right? Don't let the jurisdiction heading fool you. But oh man, by this point, Ms. Mukantagara's son was no longer a child, meaning he was no longer a derivative on her application, meaning that he didn't get asylum when she got asylum the second time. What a cruel situation. Assuming no genocide, of course. Apparently, the son didn't warrant asylum in his own right, and so the son was left without status and was ordered removed to Rwanda. The son, now an adult, Mr. Shayaka, appealed to the BIA. DHS appealed Ms. Mukantagara's grant. The BIA vacated the IJ on Ms. Mukantagara and affirmed the IJ on Mr. Shayaka. But on remand, the IJ granted Ms. Mukantagara's application again. DHS appealed again, and that appeal remains pending before the BIA. Mr. Shayaka has a final order of removal. During all of this, Ms. Mukantagara and Mr. Shayaka filed a complaint against USCIS and the whole squad in federal court, challenging termination of asylum status, which after all the IJ held that it lacked jurisdiction to review. The reason, if you're connecting the dots, is because if asylum status was improperly terminated, Mr. Shayaka gets to be a refugee again and can then adjust to lawful permanent resident status. And again, no matter what you think of Ms. Mukantagara, Mr. Shayaka certainly did not engage in any genocide, but he is the one being punished the most in this whole decision. But if a federal district judge can't review termination of asylum status, then no one, literally no one on the planet it seems, can review USCIS's decision to terminate asylum status. Except maybe the AAO? I don't know. Seems like not though under a regulation. Unclear to me. AAO notwithstanding, that's exactly what the district court judge held. No jurisdiction to review termination of refugee status, at least under these facts, under INA Section 242b(9). The 10th Circuit did not agree. The jurisdiction stripping provision is known, a bit appropriately, as the quote, zipper clause, end quote. And yes, that is the raciest joke you will ever hear on this legal podcast. The zipper clause reads, quote, judicial review of all questions of law and fact, including interpretation and application of constitutional and statutory provisions, arising from any action taken or proceeding brought to remove a non-citizen from the U.S. under this subchapter, shall be available only in judicial review of a final order under this section, end quote. Put in a bit of layman's terms under old Supreme Court precedent, that means that all, quote, decisions and actions leading up to or consequent upon final orders of removal, end quote, must be brought first to immigration court, then to the BIA, and then to the circuit through petition for review. You can't shortcut that process through federal district court. So the Supreme Court said in Reno v. Am Arab Anti-Discrimination Committee, in language that the 10th Circuit expressly recognizes as dicta. Dicta aside, what is actually covered? Because again, the immigration judge determined that the IJ can't determine whether USCIS properly terminated refugee status. So if he can't challenge it in federal district court, You can't ever get review of that issue. So what's actually covered by the zipper clause? To a degree, there's a lot of things that oil and AUSAs can argue lead up to or arise from removal proceedings or removal orders that would therefore strip federal district courts of jurisdiction. And don't you worry, DOJ argues literally everything fits inside the zipper. Okay, that is the raciest joke you will ever hear on the podcast. I'm done. But seriously, DOJ argues everything all the time is barred by Section 242b9. And anyway, Supreme Court dicta can be a powerful thing. DOJ took the position here that termination of asylum status is a, quote, triggering event that arises from an action taken to remove a non-citizen, end quote. The 10th Circuit did not agree. Now, there is a regulation that states that when refugee status is terminated, quote, USCIS will process the non-citizen under Sections 235, 240, and 241 of the Act, end quote. And Section 240 is removal proceedings. So there's a pretty clear line between termination of refugee status and initiation of removal proceedings to give DOJ and DHS some credit on their jurisdiction argument. Putting aside the fact, of course, that DHS is relying on its own regulation for its jurisdiction stripping argument, such are the privileges of arguing for the U.S. government. And the district court relied on this argument. The district court judge believed that that regulation mandated that removal proceedings be commenced upon termination of refugee status, and so the whole thing implicated the zipper clause. It's all connected and therefore strips district courts of jurisdiction to review termination of refugee status. But the 10th Circuit saw that as a, quote, expansive reading, end quote, of the zipper clause. This is contrary to the narrow scope recently explained by the Supreme Court in the DACA case, DHS v. Regents. Quote, Congress did not intend the zipper clause to cut off claims that have a tangential relationship with pending removal proceedings, end quote. Quoting none other than KKTP Wind Canal A Media Holding LLC v. USCIS, by the way, episode 11. As to that pesky regulation I mentioned, well, quote, the lack of USCIS's discretion to commence proceedings does not bring its prior status termination decision within the zipper clause statute. Rather, the regulation strips USCIS's discretion whether it should take action to remove a non-citizen under the circumstances, end quote. The specific arguments we litigators make in court are so important. Quote, plaintiffs do not challenge their removal proceedings. Rather, they challenge USCIS's determination to terminate refugee status, end quote. That is not a challenge to a decision to commence, adjudicate, or execute removal proceedings or a removal order. The zipper clause, quote, has no role to play, end quote. Quoting Canale Media. The case is therefore getting remanded back to the district court for a determination of whether or not USCIS properly terminated Ms. Mukantagara's refugee status and that of her son. But I'll tell you this. The fact that an immigration judge has now twice concluded that the record does not support a genocide finding is a heck of an administrative fact for plaintiff to rely upon on remand. Seems like Ms. Mukantagara's son has a good chance of getting his derivative refugee status back even though he's now an adult, and maybe a green card soon. What a fight. I loved every minute of that decision. Meaning, congratulations Daniel R. Black and Marty L. Jones for plaintiff appellants. And that is Mukantagara v. DHS. Next up is USA v. Harris and USA v. Jenkins, published by the 3rd Circuit on May 17th and May 18th, 2023. Before we take a short break, I wanted to talk about 2 crime of violence decisions issued by the 3rd in the sentence enhancement context. They're complicated and they're wonky, so I'm going to do my best to cut to the chase for those lucky enough to tango with Pennsylvania crimes on a regular basis. First, USA v. Harris. As so often with these decisions, this case is about a lot of things that don't affect immigration practitioners, but here's what does. In this decision, the court held, in part because of the Supreme Court's recent Borden decision, that neither Pennsylvania first-degree robbery nor certain forms of Pennsylvania first-degree aggravated assault are Armed Career Criminal Act violent felonies. Indeed, the government had to concede the robbery issue, as clearly, quote, 2 of the 3 subsections defining first-degree robbery can be committed recklessly, end quote. And for another robbery conviction, it appears that the statute is divisible, and Mr. Harris was convicted of a portion that permits conviction through reckless conduct. And as we all know after Borden, a statute that might be a crime of violence, but that can be committed with regular recklessness, does not satisfy the violent felony or crime of violence definition. So Pennsylvania robbery appears out. That then left Pennsylvania first-degree aggravated assault. But see, in the 2023 Pennsylvania Supreme Court decision United States v. Harris, the court held that, quote, force is not an element of first-degree aggravated assault, end quote. The Third Circuit had sent the question in this very case directly to the Pennsylvania Supreme Court for an answer, and the Pennsylvania Supreme Court came back and said that although, quote, the attempted or actual infliction of serious bodily injury is a required element, the perpetrator need not use force to inflict such an injury, end quote. And of course, circuits must defer to state Supreme Courts when it comes to the element of state crimes. Now, true, the first-degree Pennsylvania assault crime, 18 Pennsylvania Statute Section 2702A, is divisible into 2 subsections. And although the conviction documents are a bit unclear here, the Third Circuit concluded that Mr. Harris was convicted of a subsection 1 offense. So Section 2702A1. Under that subsection, an individual is guilty who, quote, attempted to cause serious bodily injury to another or causes such injury intentionally, knowingly, or recklessly under circumstances manifesting extreme indifference to the value of human life, end quote. But not only does that not necessarily require violent force, as the Pennsylvania Supreme Court recently held, it seems to have the reckless mens rea that Borden explains destroys a crime of violence finding. Plus, there's prior Third Circuit precedent directly on point. Other subsections of first-degree assault maybe require violent force, but not subsection A1. Caveat, be careful on the Borden thing though. It seems like the Third Circuit might read the mens rea more akin to extreme recklessness, which might therefore mean that the crime has a sufficient mens rea to be a crime of violence. So I qualify a bit there, and I digress. Because this decision is more about the use of force, or lack thereof, with the Pennsylvania first-degree assault statute. To the Third Circuit, and apparently the Pennsylvania Supreme Court, quote, an act of omission does not constitute an act of physical force, end quote. It's an omission, it's not force. And there's at least one Pennsylvania case where an omission-type crime was criminalized under this Pennsylvania first-degree aggravated assault statute. It's a Pennsylvania state law case, which has nothing to do with this case, or immigration, that involved a conviction for an omission that resulted in, quote, starving a child to death, end quote. Pretty horrific, but doesn't matter. That is still not violent force. Reason to the court. There's no force at all. There's an absence of everything, really. But the crime of violence and violent felony definition is tied to the use of force. Ipso facto, the statute is not a violent felony or a crime of violence. While some might chafe at the rule on this analysis, the Third Circuit does not, at least in the sentence enhancement context. Quote, this approach is under-inclusive by design. It expects that some violent acts, because charged under a law applying to nonviolent conduct, will not trigger enhanced sentences, end quote. Interesting to remember, as of course that same analysis, the categorical approach and therefore congressional intent, applies in immigration equally. And after all, isn't losing one's green card and permanent banishment just as severe as getting a criminal sentence enhanced by a few years? Not a frivolous question to ask as a society. Neither of the Supreme Court's other recent decisions on violent force, Castleman or Stokeling, changed the relevant analysis to the Third Circuit or its conclusion. A must-read for crime of violence and assault-type statutes. And I kind of breezed through it. But read it in the Third Circuit, crimmigration folks. So that's USA v. Harris. USA v. Jenkins was issued the next day, and apparently intentionally, because it asked, quote, is second-degree aggravated assault of a protected individual in violation of 18 Pennsylvania Statute Section 2702A3, a violent felony under the Armed Career Criminal Act. We hold it is not, end quote. Naturally, this is a lesser type crime than is the first-degree aggravated assault crime that we just analyzed in Harris. And to the Third Circuit, this lesser version of aggravated assault in Pennsylvania also doesn't require the violent force, quote, capable of causing physical pain or injury to another person, end quote, that the violent felony definition requires. Section 2702A3 applies to one who, quote, attempts to cause or intentionally or knowingly causes bodily injury to any of the officers, agents, employees, or other persons enumerated in another subsection in the performance of duty, end quote. No recklessness there, although the listed persons are most definitely, if not entirely, government employees of the state of Pennsylvania. But the Pennsylvania Supreme Court's decision in Harris that we just discussed again shows that the assault crime in Pennsylvania, even in the second degree, doesn't require violent force. Again, it's that failure to act thing, the omission. Just like subsection A1, second-degree assault in violation of subsection A3 permits conviction through an omission without requiring force of any kind. That's what the Pennsylvania Supreme Court has essentially said. It doesn't matter that subsection A3, the second-degree assault, lists a specific victim class. Those, quote, additional elements are relevant only if they specify how a defendant must cause or attempt to cause bodily injury, end quote. Emphasis by the court. And they do not. They're just listing protected individuals. To be clear, there exist certain ways to commit first and apparently second-degree aggravated assault in Pennsylvania that would equate to violent felonies and, I guess, crimes of violence. But not these two subsections that we just discussed. Quote, what a world, end quote, concludes the court. Indeed. I'll leave you with this on the realistic probability test from Jenkins. In Jenkins, the Third Circuit cites to the Supreme Court's recent Taylor decision, along with Duenas-Alvarez, of course, in a manner that myself and many others have been pounding since Taylor was issued last year. Go check the receipts on episode 113. Allow me to quote the whole thing from the Third Circuit here. Quote, the government stresses that Mr. Jenkins cannot point to a single conviction under Section 2702A3 for a failure to act, but he need not do so. The realistic probability test, which requires defendants to show a realistic probability, not a theoretical possibility, that the state would apply its statute to conduct that falls outside the generic definition of a crime, does not apply where the elements of the offense, whether as set forth in a statute or case law, do not match the generic federal crime. In other words, the realistic probability test is implicated only when the relevant state and federal offenses clearly overlap, end quote. Want an even clearer recitation? Quote, the realistic probability test thus plays no role, even if, as a matter of common sense, it is scarcely conceivable that one could, as a factual matter, violate the statute in the overly broad manner, end quote. You don't need to find a case. It doesn't matter if the case exists or not if the statute is textually overbroad. The realistic probability test is not a sword for the government, but instead is a defense for criminal defendants and non-citizens to avoid what appears at first blush to be a statute that satisfies the categorical approach. I'll be beating this horse, dead or alive, during presentations at the National Lawyers Guild and AILA National Conferences in Orlando next month. See you there. Then again, the podcast is free. And that is USA v. Harris and USA v. Jenkins. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOURNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. That brings us to our last case, Ruiz v. U.S. Attorney General, published by the 11th Circuit on May 18, 2023. This case is about just what it means to have been battered or subjected to extreme cruelty. And there aren't that many cases on the subject, so listen up. Ms. Ruiz is from Peru and entered the United States with a 6-month non-immigrant visa in 2001. She married someone shortly thereafter, and that someone was either a U.S. citizen or a lawful permanent resident. A year into the marriage, Ms. Ruiz was diagnosed with breast cancer. Quote, she received chemotherapy and, as a result, lost her hair and broke out in hives, end quote. And really, just horribly, her husband then became cruel to her and said things like, quote, if they removed her breast, that was the end of it, end quote. When she got a mastectomy anyway to save her life, her husband kicked her out of their bed, grabbing her and forcing her to look at herself in the mirror, yelling that she wasn't a woman anymore. Her son corroborated all of this in immigration court. The husband then filed for divorce, sought a restraining order against Ms. Ruiz, and took $2,500 from their joint bank account. Ms. Ruiz was never really physically harmed other than being grabbed on the arm that time, but she, quote, suffered PTSD and underwent therapy. Happily, Ms. Ruiz is now cancer-free, end quote. She is, though, removable. She overstayed her visa, and it would seem, never adjusted through her, as reflected in this decision, schmuck of a husband. But the positive of all of that is this. It provides grounds for a smart attorney to argue that Ms. Ruiz is due special rule cancellation of removal under INA Section 240A-B2, VAWA cancellation, as a non-citizen who has been battered or subjected to extreme cruelty by a U.S. citizen or a lawful permanent resident spouse. When Congress used to legislate in the world of immigration beyond simple wall-building politics, quote, Congress enacted what is now special rule cancellation as part of the Violence Against Women Act to enable certain victims of domestic abuse to obtain discretionary deportation relief, end quote. It's a much easier form of cancellation of removal to get than regular non-LPR cancellation. It only requires 3 years continuous presence, and a compliant notice to appear does not cut off accrual of continuous presence, I believe. The hardship showing is lower, only extreme, not exceptional and extremely unusual, and the applicant herself can be the qualifying relative. Much better form of relief. If, of course, you can show that you were battered or subjected to extreme cruelty. What does that phrase mean? It's not really defined under immigration law. Many people assume that it requires physical, terrible domestic violence. But that's not actually in the law. Based on how the immigration judge ruled, though, Ms. Ruiz argued to the BIA that the IJ impermissibly believed that, quote, extreme cruelty required proof of physical violence and excluded mental or emotional abuse, end quote. The BIA kind of avoided the issue and upheld the IJ's decision. So Ms. Ruiz brought it to the 11th Circuit, which took the issue head on. But first it had to wrestle with that awful bear that is Patel. And this is the 11th Circuit, the capital of Patel County, USA. What we have here is a challenge to a no hardship showing in the cancellation of removal context. Very well might be excluded from circuit review under Patel. Indeed, the 11th Circuit had said so pre-Patel. But, in what admittedly is a bit of a shock to me, the 11th Circuit panel read the Supreme Court's Patel decision a bit favorably on the issue. Patel did, after all, technically vacate prior 11th Circuit precedent on jurisdiction, including the one relied upon oil here, albeit by then in Patel implementing an arguably even harsher jurisdictional rule. But to the court, as with many circuits post-Patel, but not all, the 11th Circuit reads the Supreme Court in Patel as having, quote, echoed the distinction that we had drawn between questions of fact, over which we lack jurisdiction, and questions of law, over which we retain it, end quote, even when the underlying application at issue is cancellation of removal. It's becoming a complicated circuit split when all of this cancellation of removal stuff can be reviewed even if it's a question of law, and quite frankly, I'm not even sure if all the courts and panels know where everyone is landing. So that's a gong. Anyway, to the court, whether an IJ misinterpreted the VAWA cancellation statute as requiring proof of physical abuse to qualify as extreme cruelty is very much a question of law that the 11th Circuit has jurisdiction to review. Restated in broad terms applicable to all petitions for review, whether an IJ applied an incorrect legal standard to a hardship determination appears to be reviewable in the 11th. In fact, it's a, quote, quintessential question of law, end quote, at least when you can tie the issue as one that regards the, quote, meaning of a statutory provision, end quote. Y'all listening? Can't wait for that next 11th Circuit decision. Now, whether what Ms. Ruiz experienced meets the standard is no longer reviewable, said the 11th Circuit, and apparently Patel. But whether the IJ and the BIA applied the correct legal framework is. So let's review it. What does extreme cruelty mean? I hope you're listening, Mother. To the 11th Circuit, the immigration judge below indeed required that a VAWA cancellation applicant bring forth evidence of physical violence, physical harm, or physical abuse. And that was not correct, explained the 11th Circuit. The BIA has never spoken directly on the issue in a precedential decision, explained the court. That left the 11th Circuit to turn to the trustiest of sources, quote, VAWA-era dictionary definitions, end quote, from 1994. And those dictionaries define cruelty to include both physical and mental abuse, and make clear further that cruelty is a, quote, term of art in the family law context, end quote. Mental suffering qualifies, as do, and I love this one for arguments, quote, acts or omissions of such character as to destroy peace of mind or impair bodily or mental health of person, upon whom inflicted or be such as to destroy the objects of matrimony, end quote. That's a standard, huh? Regulations in what I believe are, in another VAWA context, corroborate this understanding of the definition of extreme cruelty under immigration law. Psychological abuse and mental suffering cut it, even if not physical. That means that the BIA and presumably the IJ need to review Ms. Ruiz's cancellation of removal eligibility again, recognizing that the mental and psychological abuse that she suffered can qualify if sufficiently severe. Remand. Judge Newsom concurred to explain a very wonky issue of judicial review regarding the meaning of INA Section 103A1, that if ever taken up in a majority opinion, could blow holes right through a lot of immigration law. Give it a read if you're looking for a flamethrower of a circuit court argument. Might be all moot anyway if the Supreme Court vacates Chevron next term. Who knows? So to conclude, Ms. Ruiz's ex-husband appears to suck, but in a roundabout way has created some excellent law for future victims of domestic violence and extreme cruelty in the 11th Circuit, and really, nationwide. And although the 11th Circuit doesn't put the attorneys in the day of decisions, so I can't confirm, nerdy immigration lawyers tells me that at a minimum, Annabella Trujillo is due praise for repping petitioner on this wonderful win. Congrats, counsel. And that is Ruiz v. U.S. Attorney General. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.